for community legal services. I handle mostly areas of foreclosure, real estate, and bankruptcy. So if you come to us for assistance, I'm exactly the person you'll get to talk to. Tonight, what I'm going to do, oh my goodness, let's see if we can get this to actually advance. Oh, there we go. Good. I'm going to talk a little bit about what foreclosure is, because there are terms and concepts you need to be able to effectively communicate with your lender or servicer, as well as attorneys or people you might seek assistance with. There's a little bit of history I got to go into about it, because foreclosures are deeply steeped in sort of tradition of how society has treated property. We'll talk a bit about the Maryland process so you can understand different points of sort of intervention and what options can happen in different places. And then we're going to talk a lot about the steps that you can take, because there are definitely things you can do to make your situation better. You absolutely can take control of it. This doesn't have to be an out of control process. So first thing I want to go over is sort of the language of foreclosure, because it is different from what you may think. There's a lot of different ways that different people use foreclosure. I'll get into what it really means in a bit. But some of the things you're going to hear are issues like acceleration of a debt versus being late on payments, right? Being late, yeah, you're late on the payment. We all sort of have a sense of what that means. Acceleration, on the other hand, is a very specific term where the lender or servicer will no longer accept payments that are less than the full amount to bring the loan current. And so sometimes homeowners, when they're a month or 2 or 3 behind, they'll try to send in whatever they can because they're trying to show good faith or whatever, and they don't understand why the bank is sending money back. It has to do with this situation. That kind of gets to the second point here, which is reinstatement versus the amount that you owe. Reinstatement is the amount you have to pay to bring the loan current. The amount owed is kind of what you owe that day when you ask that question. And this has to do with how servicers and banks account for interest. And that is a little bit accrues every day. And so if you call on a Tuesday and they say you owe $500, and then you try to send them a check for $500, it won't get there until Friday. And on Friday, you owe them $527.38 or whatever the interest schedule is. And they'll reject your payment. So you have to ask for things in kind of a particular way, which sounds, I know, sort of needlessly sort of form over substance, but this is how the game is played, okay? And so when you talk to them, you have to ask for a reinstatement quote, which is, I would like a quote to reinstate my mortgage. And they'll say, you owe $527.26 good through whatever date that is good through. So as long as you get them that amount of money by that date, you will successfully reinstate your mortgage, okay? There are paperwork issues that come up. So you need to understand the difference between a deed versus a deed of trust versus a note versus a mortgage, okay? We generally call things the mortgage. That's the mortgage. There's the deed. This is a very important document. This is the thing that actually says you own your house, okay? And a lot of homeowners, honestly, are confused on this point. They feel that because they still have a mortgage that they don't really own their house because it isn't paid off yet. No, you own your house. You have very definite and specific set of rights because of that ownership. And it's that ownership that allowed you to pledge the house in trust for this sum of money you borrowed, which coincidentally you used to buy it, right? But that is the instrument called the deed of trust. And that is what secures this money against the house. That is different from the note. The note is the actual contract promise to pay the money back okay? And a mortgage is sometimes used interchangeably with all of this stuff. We'll get into that in a little more detail in a bit, okay? And again, I touched on this idea of home ownership versus a leased home and this concept of the home pledged as collateral for the loan, okay? So it's important to keep these relationships straight so that you understand your status in the process. Okay, what is foreclosure? This is a little bit of history, a little bit of everything in here, okay? So we talk commonly about mortgages. It comes from two words, mort, meaning dead, and gage or gage, which had to do with a particular form of contract or pledge way back Norman conquest of English time. Old term, right? Literally, it means dead pledge. It's the idea that this contract has a point in time where it's going to just die a natural death. And that is ideally the time when you make your last mortgage payment, okay? Traditionally, with this kind of contract is this thing called the equity of redemption. And you have to understand, mortgage law is equitable law. You are literally on the scales of justice, and a judge is asked to weigh each side when they look at these questions, okay? So the equity of redemption says that if you're in default on the contract at any time prior to the termination of your right to do so, you can pay all the amounts you owe and mend the contract. Okay, this is the equity of redemption. You redeem the contract. That is what foreclosure is. It is the actual act of terminating your right to bring the amounts current. Okay, it happens to coincide exactly with the time of sale, but that's what it really is. It's important to understand that because most foreclosure sales are lender purchase backs. And homeowners feel like, well, can't I just pay them the money and get back in? The answer is at that point, no, because your equity of redemption has been terminated by the foreclosure process when that happens, okay? Servicers use it imprecisely all the time too. Usually when they say, dear homeowner, you are in foreclosure, what they really mean is we have accelerated the debt and referred your debt, your file, your account to an attorney. And in Maryland, this attorney is usually called either the trustee or the substitute trustee. So when you get documentation from the court and you'll see some group of people referred to as the substitute trustee, that's the law firm, the attorneys who are actually going to conduct the foreclosure sale and conduct the foreclosure proceedings on behalf of your lender, okay? And homeowners often use it to mean any of the above things. I'm in foreclosure. And that's kind of the first statement I hear out of so many clients. And I have to dig through what exactly is going on to find out what stage they're in and what it means, okay? So to a certain extent, you know, when you call an attorney, you're scared, you're frustrated, you're stressed out like you haven't ever been in your life. And we have to ask these sort of seemingly meaningless questions to you. It's because we're trying to parse this piece so we have an idea of what we're really dealing with here, okay? So again, a lender, typically when they say you're in foreclosure, they're saying, we have accelerated the debt. You can't pay anything less than a fully reinstating payment. And they're not going to accept it because if they do, they're actually waiving certain rights to be able to proceed with the foreclosure, okay? So you need to understand that because a lot of times homeowners feel like lenders aren't being fair because they can't make these partial payments. I've got $500, they won't take it. They won't take anything less than a full $6,000. This is why it has to do with these concepts of how the foreclosure can proceed, okay? People involved in your loan. It's very important they keep these people straight. because they each have different rights and roles in your lives. Okay? So there's the secured party or the lender. A lot of times people think this is the person who they originally got the loan out of. I got my loan from the local bank of my town, right? That's not how banking works. Your loan can be freely traded like bubblegum to anybody around the world that they want. Whoever's holding it at that time, that's your lender, okay? Usually the entity you interact with is the servicer. They're the people who actually track payments, make sure that money gets sliced and diced and sent off to the right people, some to your insurance company, some to Prince George's County to pay property taxes, and all the rest of it. And they track everything, and they hire the law firms and are the pseudo client prosecuting the foreclosure. The lender is almost never directly involved, except sometimes with particularly closely held mortgages in very specialized circumstances, okay? And the trustee, again, in Maryland, these are the actual attorneys who are conducting the foreclosure. And if you look at your loan documents, you'll see that there's almost always a trustee named. Usually it's the attorney with whoever the closing company, title and settlement company you had is. They're almost never the person who conducts the foreclosure. Instead, whoever the servicer is can designate what's called a substitute trustee, and the deed of trust gives them the power to do that. And that is who is the law firm that's hired to conduct the foreclosure. Okay? You don't actually have a mortgage, right? You have in Maryland a deed of trust, typically. For most purposes, it's the same as a mortgage because it secures a debt against a piece of property, and it provides for remedies in the event of default, which, by the way, are not limited to just foreclosure. They can also go after bank accounts and try to garnish wages. The rabbit hole goes deep on this, everybody, okay? It's different from a mortgage in that it has provisions that allow the trustee or substitute trustees to have the power to sell your house. It contains your consent to a decree foreclosing the rights of redemption. And it appoints the trustee who is conducting the foreclosure. Again, this can later become a substituted trustee, okay? And this structure is why you'll often hear why there are no foreclosure trials. There's no judicial foreclosure in Maryland. Instead, everything's done under expedited hearings under the judicial rules, which I'll give you links and things to in the future, so in case you want to actually read these rules, because you can see them for free. Your mortgage has multiple parts you need to understand, right? Again, there's the deed. That's your actual ownership. It's not really part of the mortgage, but it's what gives you the right to enter into the mortgage or the loan, right? This has to be recorded in the land records first, because until you have a recorded interest, you can't legally pledge a loan against the house, okay? There's the deed of trust. That has to be recorded immediately after the deed, okay? And then there are issues of priority that can come up, which I'll explain in just a moment. And then again, there's the note. That's not recorded in land records. This is just held in the bank's back pocket, and it is your promise to repay the debt, okay? So the things to really take here, right? Your loan has multiple parts. Got to keep them straight. They're controlled by multiple people or companies, and you have to keep them straight. And the rights are all determined, and I'm going to say this now, as first in time, first in right. Some of you may have situations where you have a first mortgage and you have a second mortgage. And perhaps you are not behind on your first mortgage. And maybe years ago when your house was way underwater, you stopped paying your second mortgage. And your second mortgage never foreclosed. They just kind of went away. They didn't go away. They were waiting for a time when your house has equity, because payments at foreclosure happen first in time, first in right. So the reason the second mortgage didn't foreclose was because they would spend thousands of dollars on an attorney to foreclose and then not get paid anything. But now they will. And that's why they're showing up now, even though you haven't heard from them since 2007. All right, a little bit about the foreclosure process in Maryland. Feel lucky that we are post 2008, because prior to 2008, as a homeowner, you didn't even have a right to be notified there was a foreclosure happening at all. Strictly speaking, the first you'd hear about it is 15 or so days after the case got filed. Someone would knock on your door and say, when are you going to move out of my house? It was in 2008, with the housing collapse, that the Maryland legislature passed the Maryland Protection of Homeowners and Foreclosure Act, which provided for all of the rules of procedure now, which actually make sure that you as a homeowner get notice, and statewide organizations such as Community Legal Services, who I work for, and Civil Justice and the Pro Bono Resource Center, all came together to train thousands of attorneys to address this thing. Because in 2008, I think there were something like 10 attorneys in the whole state that did this, and there were over 10,000 filings a month. So there was a real crisis then. We're a little better off now. Okay, the basic process. And I'm going to make some notes here with respect to bankruptcy. I know it's a bad word, it's scary. We'll talk about that in a bit. But first, I want you to sort of see the points where it's important to be thinking about it. And then we'll talk about why, okay? So, default through the first 45 days. Not much really happens there. Generally, as many of you note on your bills and your mortgage statements, you have some grace period time, 15 days or so, to make a payment without having late penalties. And as long as you pay within time, generally no one's going to make any stink, especially if you pay the late penalties if they accrued, right? But understand this, default, strictly speaking, is 1 day late. If you are 1 day late on your mortgage, you have started the clock ticking to foreclosure. Now, maybe your payment gets there the next day. Clock resets, fine, right? But when you dance with that deadline, you are dancing with the foreclosure clock. And you need to understand that very carefully, okay? After that 45 days, if no payments have been made, right, then the process says that the lender can send what's called a notice of intent to foreclose. Some of you may have received this in the mail. It has specific information that's required to be in there, like how to contact the people who service and own your loan and things like that. The intent there is to try to give you, the homeowner, the tools you need to reach out for assistance and try to come to some accommodation to save your home, okay? This document precedes the actual filing of the case by another 45 days. So, strictly speaking, in the Maryland timeline, 90 days after you are late on that mortgage payment is when the court case can commence, okay? Now, these are all, let me stress, minimum times. There are federal rules and regulations which generally expand these times in favor of homeowners, and generally, no one is exactly Johnny on the spot with these timelines, okay? But they're here because I want you to know the minimums, okay? Your order to docket comes in one of two flavors. No Baskin Robbins, no 31 flavors, we've got two. The first is the preliminary loss mitigation affidavit, okay? And you'll see I have this 30-day notation. The second is the final loss mitigation affidavit, and you'll see I have a 25-day notation. So what are these things? Preliminary loss mitigation affidavit, in short, says, "Dear court, we think we're going to have to foreclose on this house, but we haven't done everything we possibly can to look at it and see if there's some way we can work it out with the homeowner, or we've been having trouble reaching the homeowner, or whatever. We think there are steps maybe that could happen, so we're not 100% certain. So that we're filing this case like a little placeholder." Okay? If you, the homeowner, during this first 30 days, get all the documents that the bank requests into them, and with this filing, you will get a list of the documentation they request. If you get it all into them within that first 30 days, they have to consider it and will look to see whether they can modify you or do something short of foreclosure. And if you successfully modify your loan, they will voluntarily dismiss the foreclosure case. Okay? Because modification, by its very terms, brings your loan current. And when your loan is current, the lender no longer has the right to proceed in foreclosure. So this is a really important step to recognize, notice, and work with. Okay? If you don't do anything, or if the bank has been working a long time to try to work stuff out with you, you'll get the final loss mitigation affidavit. This can be filed with the initial filing or mailed to you after the expiration of that 30 days. Okay? Final loss mitigation affidavit in brief says, "Dear court, we have done everything reasonably, commercially practicable to try to work with the homeowner, and we believe nothing can work out and we have no choice but to foreclose." That doesn't mean the story is over. That document is what triggers your right to request mediation. Okay? And by the way, let me talk a little bit about mediation in Maryland. There are special rules for that. You generally have a right to either mediation before the order to docket is filed or after, but you don't get both. And for reasons that individual attorneys can advise you about, generally, no attorney I'm aware of believes that it is worth giving up your post-file mediation for a pre-file mediation. Just so you know. Okay. You have 25 days from receipt of the final loss mitigation affidavit to request mediation. Okay? If you don't, then your motion to stay or dismiss pursuant to Maryland Rule 14-11 becomes due. So it is generally considered in homeowners' interest to try and work with lenders and request mediation. A motion pursuant to Maryland Rule 14-11, assuming you request mediation, is due 15 days after the mediation. Okay? At any point up to this time, bankruptcy can be a useful tool in managing the process. Okay? And because of how most homes in Prince George's County are structured, I make a special note here that up until this point, you continue to owe condo and homeowners association, HOA, fees. Okay? Because your next step is sale. And at sale, you no longer have proper title to the property. So you no longer owe HOA or condo fees going forward. But by virtue of this title having been severed, you no longer have any means to save the home through bankruptcy. It can no longer be brought back in to the bankruptcy estate. So the sale date is an insanely important day. Okay? After the sale, there's a period of 30 days for the report of sale to be filed. This says the price that was paid, how much commissions everybody made, all of these sort of accounting things that happen. After that, there's a period of time for the homeowner, 30 days, to file exceptions to the sale. And Maryland law has limited things to where you are limited in what you can raise as a complaint. You can't complain about anything at this point that you could have complained about prior to the sale. So you're stuck to things like the sale wasn't fairly conducted, the sale itself, not the sale should never have happened, not the bank behaved fraudulently at some point 6 months before the sale. None of that can be raised after this point. Okay, if you want to argue any of that stuff, that has to be done before the sale, or the court will simply refuse to hear it. Okay. All right. At any point after that, the court can ratify the sale. And once the sale has been ratified, it is done. Done like the most burned Thanksgiving dinner you have ever seen in your life. It is done. Okay. At that point, the next steps would be a motion for possession. Okay. And you need to understand here, the foreclosure rules prescribe a process for applying through the circuit court for possession via Maryland Rule 14-102. But our district courts are allowing an expedited process, which I have unsuccessfully been trying to argue is wrong. But it actually happens through the district court under the provisions of the Maryland Code that have to do with squatters. And that is a process called wrongful detainer. This can be a process that, unlike the circuit court process, gives you 30 days notice and a time to state your case to the circuit court, and generally allows you to explain circumstances why you should be given more time to move and things like that. This is an expedited process that will have technically the sheriff able to show up and put you out of the property within 10 days. And so you need to be very aware if you start seeing service from the district court that things can get really tight there. Okay. And at any point in this backside post-sale process, bankruptcy is still useful for managing the debt and managing any collections cases happening against you. Okay. Bankruptcy is a terrible word. I know. Parents have told us it's the worst thing that can happen. It's awful. You're a failure. It's an embarrassment. All of these things. I know. Look, think about this logically. The government, however evil you may think they are, did not go through all the trouble to set up a statutory process and special courts and hire all these clerks and do all this stuff to try to make the worst thing possible happen to you. There's obviously something worse. There is. It's being helpless before all of your creditors. The bankruptcy court has a judge who is the adult in the room and says, let's all play nice in the sandbox and figure out how people get paid and how things get done and what's no longer practicable, and we're not throwing people in debtors' prisons. Okay? And that's what it's for. Talking about bankruptcy, thinking about bankruptcy does not mean you are a failure. It does not mean you are a bad person. And it doesn't mean even that you're going to file bankruptcy. It means you're looking at, is this a reasonable way to address the problem? Okay. Bankruptcy is a process that is here for, as the Supreme Court has said in numerous cases, this is language you hear all the time, the honest but unfortunate debtor. Look, bad things happen to people, oftentimes not for their own fault. And that's what the process is for. Elizabeth Warren, when she was a bankruptcy professor, published a study demonstrating that most people file bankruptcy because of loss of a job or illness or divorce or things that largely are not their fault. And So you shouldn't really feel that it's a knock against you, okay? And I'll be perfectly frank, there's no more sympathetic place for debtors in distress than bankruptcy courts. The judges there have seen just about every bad luck case there is, and they're very practical about it. And they're not going to spend their time waggling their fingers at you about what a bad person you are. They're going to look at how do we get everybody made in the best situation that we can. And that's what they're all about. Foreclosure and bankruptcy really are part of what I think of as a trifecta of problems, right? Bankruptcy, divorce, and foreclosure is my sort of standard triangle I think about. Because of the economic pressures in our county, typically young families will buy a house together based on two incomes, right? Mom and dad are working, their two incomes together can finally afford a house, a roof over their heads, and the roof for the kids, right? Now, a lot of things can happen to mess up this triangle. Sometimes mom and dad can just have problems unrelated to finances or whatever, just doesn't work out. But the problem is there's a house that was sustainable on two incomes, and now we have to sustain two separate households, one of which is this house, which was only sustainable on two incomes. And so that's going to cause this triangle to destabilize. Sometimes someone will lose a job. And again, the house is not sustainable. This leads into foreclosure, family stress, it starts divorce, it starts bankruptcy. You can go in any direction. There are scenarios for all of them, but they all tend to go together. All right. And so one problem can often bleed into the others. So when you look at it, you have to look at it from all of these things at the same time. All right. Little bit about bankruptcy and how it can help you out. Bankruptcy has something called the automatic stay. It stops all collection actions as soon as you file that bankruptcy, okay? It's going to provide a minimum of 30 days breathing room to figure stuff out, okay? It can be limited if you are what the court regards as a serial filer. That is, you have multiple cases within a single 365-day period, okay? Oftentimes, I'll see this in clients where they file a bankruptcy on their own to stop a foreclosure because they know about the automatic stay. And then they keep trying to work with their bank, but they don't get their paperwork with the bankruptcy court right. Their case gets dismissed. A new sale date is set. They file the second one. And the second one will successfully still stop the foreclosure, although it's a special limited stay in that case for only 30 days. And that one worked and they still work with the bank. And then they try to file the third one. And then they go, wait a second, this one didn't stop the foreclosure. It's because on that third one, the homeowner is considered a serial filer. And boy, howdy, do they have to meet a high bar to demonstrate to the court why they should be allowed to have any protection whatsoever. This is just to say it's there for you. You can turn to it, but you gotta treat it with respect, and you gotta think carefully about why you're doing it, how you're using it, and the time of the bankruptcy court, okay? Generally speaking, if you've had one prior filing in the calendar year, you can file that second one, but you have to file a special motion with it to request that the court allow the stay to exist beyond the initial 30 days. And if you're on your third filing, you have to actually file a special motion requesting that the court put the stay in place to begin with. Two very different motions, two very different standards. And generally, in all of these cases, it's to your benefit to have an attorney involved for several reasons, not the least of which is your attorney is familiar with the rules and how to ask the court for these special considerations. All right, a little bit more about bankruptcy. Generally, there's two kinds you're going to be looking at for most of our homeowners in Prince George's County. There's Chapter 7, which I generally describe as kind of pop culture bankruptcy, there's a message here. One moment. What is this special request for stay after multiple filing? Asked someone. It is a request to impose the stay. It's called a motion to impose stay. Okay. And there are actually specific case law requirements you need to meet, as well as statutory requirements, essentially all having to deal with good faith and that you're not just trying to delay stuff. You actually have an honest belief that the bankruptcy is going to do something to benefit all the parties involved. Okay. All right. So Chapter 7 bankruptcy, pop culture bankruptcy, right? This thing we're all afraid of. We're going to lose everything and be left with all the clothes on our back and live in a cardboard box under a bridge and all this sort of stuff. In reality, it's not that bad because the Maryland legislature has put in place a series of exemptions to protect property. And the vast majority of people, all their stuff is worth less than those exemptions. Not what you paid for it. It's not the test. What could you get for all your stuff if you bulk sold it to the Salvation Army? And for a lot of people, that means their stuff is going to fall under exemptions. Okay. Another practical reason is that the bankruptcy is run by a trustee. And the trustee is an attorney that charges attorney rates to the debtor estate. And he or she has a duty to make money for the estate. So that attorney is unlikely to hold a garage sale to sell your 50-cent tea kettle at an attorney's hourly rates, because that's likely going to cost the estate more money than he or she would make having a garage sale for your stuff. Okay, so that's a little bit of sort of the statutory reasons and the practical reasons for why oftentimes debtors don't lose as much property as they fear in Chapter 7. Certain things you'll lose, yeah, things that are easy to sell for a large amount of money that you can't exempt. So if you have a house with equity, you will probably lose it in a Chapter 7 bankruptcy. If you have a car with equity, you will probably lose it in a Chapter 7 bankruptcy. If you have a valuable stamp collection, a valuable comic book collection, a spare Picasso hanging on the wall, you will probably lose these things in a Chapter 7 bankruptcy. It's true. But most people don't have that. So, yeah, assess your situations. Okay? Chapter 13. This you can think of as a United States trustee enforced repayment plan. Okay? There are certain payments you are required to make to secured creditors and priority debts. You owe taxes to local governments, to the state government, to the federal government. You owe domestic support obligations. You're behind on child support or alimony, right? The court is going to force you to pay those things in full, and it's going to force you to pay some of your unsecured debts. And let me be clear on this for people so they understand. Generally, there's three classes of debt. There's secured debt. That's like your car loan or your home loan, things that are debts tied to a piece of property. There's unsecured debt. These are credit cards, medical bills, things that are just kind of there at you, right? And then there are these priority debts, which are a special class of protected unsecured debt that are there for governments and domestic support recipients. Okay? All right. The Chapter 13 essentially is a 5-year repayment plan. So you would have to pay all your normal living expenses, pay your mortgage, pay your car notes, those sorts of things. And then you would make an additional payment on whatever you're behind on things over that 5-year period. So roughly take it divided by 60 months. And as long as you make all of those payments, your creditors cannot sell your house. They cannot sell your car. they cannot sue you for a collection action as long as you keep those payments current. Now, let me be clear, this is not easy. Debtors have problems with this all the time, but it is a valid second shot that lets you catch up on this mortgage over that 5-year period. There are some other things that can happen. For example, you can have something called a lien strip. This can allow unsecured debts that are current. Well, let me explain this. Let's say you have a house worth $150,000. You have a first mortgage that is $175,000 balance, and the second mortgage that's $35,000. Because the $175,000 is more than the value of the house in total, the second mortgage has nothing to gain upon the sale of the house. It is what we call wholly unsecured, even though it was registered and recorded as a secured debt. In certain circumstances, the court will allow and grant a motion stripping that off of the house so it would get treated with credit cards and other classes of unsecured debts. And if you succeed in your Chapter 13 plan, it will get discharged along with those credit cards. In a Chapter 13, while you're under the protection of the Chapter 13, you can still apply for a modification. It can still be approved. You'll have to get permission from the bankruptcy court to approve it, but I've never heard of the bankruptcy court not approving something that is a satisfactory accommodation between a creditor and the debtor. So it's a decent shot that if you can get the modification in the Chapter 13, it'll work for you. You can also have adversary proceedings on the debt. What does that mean? An adversary proceeding is kind of a special miniature trial that happens inside the Chapter 13 bankruptcy, okay? And you can, in this part of the bankruptcy, argue that the bank has defrauded you, they have done something wrong that says they should not get paid that amount of money. And if you have the evidence to support it, you can bring that case inside the bankruptcy court. And again, remember, in bankruptcy, there is the automatic stay. So as long as you're making your other payments, you can lose this case and you still won't lose your home, unlike other court venues. Okay. Chapter 7, help in foreclosure. It's really, most people will tell you, for clients who don't have what we call a sustainable solution, a way to keep the house. Again, if your house has equity, your house is likely going to get sold, right? It can be really important timing-wise. If you think back to the timeline I discussed earlier, right? Up until sale, you owe your HOA and your condo fees. After the sale, you don't owe any of it going forward. The bankruptcy makes eligible for discharge all debts you incurred prior to filing. So there are some decisions to make as to whether you want to owe fees going forward from the filing or not. If you want to, if you're reconciled to not keeping the house, you think you can't, right? So there are some timing issues with that. That's good to seek counsel with, okay? For clients with a sustainable solution, so my typical client in this situation is someone who lost a job for 3-4 months, maybe a little longer, I don't know, and then they get a job and their lender just isn't working with them. They're getting denied for modifications. They didn't have quite enough time to get documents together, whatever the reason is. There's a sale date. But in this particular case, the home is upside down. There's no equity. And there's a way to get the mortgage current, okay? So they've managed to save money while they've been working or whatever. In that situation, Oftentimes, the trustee may choose not to sell the house because there's no net gain for other creditors, right? Again, if $175,000 is owed on the house and the house is worth $150, if the trustee invested in selling it, he's going to net cost money to the bankruptcy estate, right? So there's a risk in those cases that the house could be sold, but oftentimes it doesn't happen because there's no net gain for the bankruptcy estate. And so in those limited circumstances, sometimes the Chapter 7 can help in that situation, okay? Chapter 13 is your more clear help in that situation, right? I have a note here that it kind of lets you evaluate sort of any deal that the bank may offer you. So let's just do some simple math to think about it. Let's say that you owe $24,000. And if you were to enter into a Chapter 13 bankruptcy, $24,000 divided by 60 months is $400 a month payment, okay? Let's say your mortgage was $2,000 a month. That means to keep your house, you're net paying $2,400 a month to keep the house, okay? If the bank is offering you a modification that's at $2,700 a month, then you already know that simply seeking protection in the Chapter 13 bankruptcy might be more affordable for you. The advantage of avoiding bankruptcy may be worth the extra payment to you, but that's a decision you would make as a homeowner, okay? But it at least gives you some way to kind of look at it and weigh what they're saying to you, the servicer, is saying to you, okay? It's a payment plan the bank can't say no to. As long as the bank's claim is fully paid off in the bankruptcy, they can't come to the bankruptcy court and say, no, they're not paying us the way we want. No, they're not paying us fast enough. No, they're not. No, they're going to get fully paid. And if it's in compliance with the bankruptcy code, they're going to take that money. And this is why oftentimes when a homeowner files bankruptcy, the bank suddenly becomes a lot more cooperative. I can't tell you to what degree or how, it varies bank to bank, but the number of times I've seen just an endless stream of no from a servicer or a bank turn into, well, yes, maybe, as soon as a homeowner filed a bankruptcy is not insignificant. Again, secured and priority debts must be brought current within 60 months. Everything else has to be paid subject to what is known as a liquidation test. This has to do somewhat with the equity in your assets. So let's say that you owe $170,000 on your mortgage again, and your house is worth $350,000. Generally speaking, you have about $180,000 in equity, right? So the bankruptcy court asked the following question: how much would everybody that the debtor owes money to get paid if we force the debtor to sell the house? Well, they'd get paid up to $180,000, right? So then in that case, the bankruptcy court would require that you would pay all of those claims up to that amount, which then would be a considerable potential hardship for some debtors, because we're talking at around $3,000 a month of a bankruptcy payment. In those cases, you may need to consider other forms of bankruptcy relief or other options. Second, I have another chat question. What are the long-term effects of having filed bankruptcy? Yeah, it's difficult to say, right? Generally speaking, the bankruptcy is going to be recorded on your credit report. People are going to see that you filed it. It's part of the public record and everything else, right? Usually people's concerns in this area relate to their credit scores and credit reporting. And I mean, I can't say specifically how it works. I'm not an expert in credit reporting, but I will say this. By the time many people have filed this, their credit scores are already pretty low. They've been pretty beat up. They've been carrying a foreclosure default, or I'm sorry, mortgage default for 6, 7, 8 months. They've had these rolling defaults, right? And so the point I often make to clients in this situation is you have two choices: bad credit with a house, bad credit without a house. And let's say that your credit score is 530. I think the theoretical maximum, don't hold me to this, but I think the theoretical, minimum is something like 475 or something like that, right? So if your score goes from 535, which no one's going to give you a loan at anyway, to 475, what does that really mean for you? I don't even know, right? But it doesn't seem terribly significant, but again, someone who knows more about credit scores and lending guidelines and stuff may have a completely different take on this from me. But from my perspective, it's kind of like, if you're already getting shot, does it matter that you get shot twice? I mean, maybe not. I don't know, right? One more chat question. Okay, so what happens after a homeowner pays the full bankruptcy plan? Okay, as I said, the bankruptcy plan requires you to bring the loan current over that 60 months. So if the loan is brought current over those 60 months, at the time your bankruptcy case is closed, you're current on the mortgage and you go forward as if it never even happened. Any unsecured debts that weren't fully paid off during that period are subject to the discharge. So if they are eligible for discharge, they're gone. If they are a form of debt that for some reason was exempted from the discharge, you'll still owe them and you'll have to pay them according to your unsecured contracts. But it depends in large part on the nature of the debts. But at least with respect to the mortgage and with priority debts, those are all caught up and paid off by the end of the 5-year period. So you're current at that point, which means your house has been saved if you have fully gone through the entire Chapter 13 period. Okay. And again, I briefly mentioned again here, lien stripping is available in Chapter 13 cases, and that can be a very powerful thing if you're in an over-leveraged property and you have that second mortgage. Being able to get that stuck in with credit cards and then discharged at the end of 5 years can obviously do a lot to make your house a lot more affordable. Okay. So those are some of the options and remedies. What are the things you can do? Okay. I'm very fond of saying that the first step to approaching any problem is to breathe. When you first encounter a problem, the kind of problems that we're talking about here, typically you become somewhat breathless, you get stressed, you start just freaking out in every way possible. First, breathe. Organize the problem. What steps are about to happen? We've gone over this, so you can refer to this and look at it. Where are we? What's about to happen? Where can I interact in this process? Where do I need help? Where I can't interact, is there someone I can go to for help to do that? What do I need to act? And how do I gather those resources? The simple step of just committing these things to paper is probably the most important thing you can do. I know it sounds corny. I know, I do. But it's so important just to organize your thoughts. How am I going to do this? It does a couple things. It gives you a mission, a task list, something to tick off. I did this for my house today. And you start to take control and ownership of the situation. And that's power. And it can really help a lot. track your case, okay? You can go to the Maryland Court website. And if you go to e-services and then you go to case search, it is free. You can look up your name, or if you've been served papers, you can look up the case number and you can get there and you can see, are they actively filing things? What's the latest stuff that's going on? Are there any court dates coming up? Any deadlines? Anything like that? Tracking this can be so important. I love the post office, but when I was living in Bowie, sometimes my mail came by a very circuitous route. It's worth being able to look for yourself and see the deadlines and make sure you're not missing something. You don't have to look at it every day. You can look at it once a week, something like that, because this will give you power over the process, okay? If you are involved in something in the federal level, you can go to pacer.uscourts.gov. It stands for Public Access to Electronic Court Records. You can get a free account, and as long as you don't look at too many documents which have a page charge, it's going to be free. I think it's like up to $25 in charges a quarter is free. And if you go over that, I think when I was running my own practice, the worst bill I ever had was like $85 a quarter. So it's not hopefully backbreaking, but anyway, you're not looking at as many cases as I did. So I'm sure you're probably okay. You can use these resources for more than just foreclosures, by the way, just as an aside. This isn't really about foreclosures, but let me just say, if you're about to hire someone to work on a deck, you can look up your contractor and see if he or she's been involved in a bunch of lawsuits and what those lawsuits were about generally. If you're looking to rent something or look at a tenant, have they been involved in a lot of lawsuits, right? You're about to buy a car. Has the car dealer been involved in a lot of lawsuits? A lot of reasons. You can look up anybody on there and see what, has been going on. Doesn't mean necessarily it's bad to get involved with them, but at least it's information that you didn't have before and something to look out for. Okay. Save your money. This is so important. This is often a make or break aspect of cases, okay? Money equals options. Now, I know right now a lot of people aren't working and things are tough. I know. But here's the deal. If you are living like you don't have a mortgage or you don't have rent to pay or whatever, you get used to that. And then you're ill prepared to adjust your lifestyle to having to pay it again. Okay. And one of the things that judges ask me all the time is, Mr. Gabel, your client hasn't paid the mortgage in over 16 months. Where's the money? You say that we can modify, you say we can do this, you say it's affordable, you say all of these things. Is there a savings account with some money here to demonstrate that? This is kind of your first threshold of proof that you can live within your means. And here's the real truth of it is that to a certain extent, that money has to go to the bank eventually. Even if you modify, you're going to pay that and more to them in interest over time. Having that money discipline is also going to make it easier to recover, because assuming that you or your attorney or whoever's helping you with this or whatever can help you work something out, you're going to have to start making payments. I often tell people this area of law is very weird in that normally you are suing someone so that they pay you money, or you're defending a lawsuit so that you don't have to pay them money. But here in foreclosure land, you are either suing the bank or defending lawsuits from the bank with the end result that you're going to pay them money. You're not arguing that you're going to pay the bank money. You're arguing how you're going to pay the bank money. That's what it's about, okay? Money demonstrates to the court you can live within your means. Money demonstrates you're responsible. And the other thing is that money demonstrates that there are potential solutions. Okay. If your mortgage is $1,800 a month, and you contend that if the bank modified you to $1,650 a month, you would be stable and able to afford everything, then logically, in your bank account should be $1,650 a month for the default period. That's pretty clear and convincing evidence, right? So that's kind of what you want to go for. But here's the other thing. Understand this. All the other options, hiring an attorney to argue things for you in circuit court if that's appropriate, or hiring an attorney for bankruptcy or whatever, all these things do cost money. And saving it is going to give you the resources you need to hire the professionals you need if that's what is appropriate. So you've got to dedicate yourself to this. Okay. Modify your life a bit. Okay. Changing utility usage, thinking about alternatives. I'll give you just a quick one that I use myself. If you think about summers in Maryland, if you wake up in the morning and the news says it's going to be 50% humidity and a high of 82 degrees, that's a nice day to sit on your front porch and sip a glass of lemonade, isn't it? It's a really nice day. It's not hot. You're not sweating bullets. You're not sticking to your cushions. Everything's great, right? So why do you have to keep your house cooler than that? Generally, it's because, I have found, you feel sticky. And so you tick the air conditioner down because you feel sticky even inside your house. And we hate that. I hate it. So I found that actually, if I run a dehumidifier in my house alongside everything else, and I set the humidity in my house at 50 degrees, I can keep my house at close to 80 degrees during the summer, and I'm very comfortable. And that cut nearly $60 a month off of my utility bill. Things like that can make a big difference. So I mentioned it. I mean, maybe it sounds obvious. I don't know. And it's all about everybody's individual comfort. And of course, if you're an allergy sufferer or something, there's all kinds of circumstances. But going through the process of thinking about it can really do a lot to help you stretch through these periods. Okay. Think carefully about your home and its maintenance. I had a client who I got a successful modification for her, but she, during the trial period of the modification, ended up defaulting because her roof started leaking, and a contractor convinced her she needed an entirely new roof, which I don't really think she did. But at that point, she then invested thousands of dollars in a new roof, and that made her miss her trial mortgage payment. So what she did was she invested thousands of dollars in an asset that she put herself in severe jeopardy of losing. And so at those points, did she really need to replace the roof, or could she have lasted 4 or 5 months by dropping $200 on a patch job and gotten through her trial period and become stable? Because at this point, you got to think about, how do I preserve the asset? Not, what's the absolute fix? I know we all want to be good homeowners and do those things, but that's not where we're at right now. Right now, we're trying to bail the ship to get it back to port because we're sinking. Okay? So it's a different sort of a thing. Think about common eating habits. I do a budget sheet with clients, and all the time I see values for eating out. And look, this is not to make anyone feel guilty or anything like that. We all do it, right? But we got to understand, in reality, $7 at McDonald's is more than 75 cents for a peanut butter and jelly sandwich. It just is. And that adds up. Another difficult one, which has been very painful for many clients, and I hesitate to mention it, but it just is it's just another area you can think about. And my apologize to everybody who this upsets, really. But you got to think about your charities and your volunteerism. I have had clients come to me who are within $300 of being able to break even and be affordable. And they're people of devout faith, and they are tithing $800 a month to their church. And I have to say to them, do you think you could talk to your pastor and maybe tithe only $300? And, then you can make your mortgage and all your expenses, because if you don't have your house, you're not going to be in the church community much longer. And that maybe is worse. And maybe you can do more volunteering in your parish or something else, and think about it differently than your tithe. And I know it's a sore point and it's really tender, but the resources are there, but you have to think carefully about deploying them. And the most important one is, don't be afraid to ask for help. This is sometimes a big one in some families, right? Sometimes a husband feels like, I have to be the provider for my family, and we didn't make the bills, and I'm a failure as a man. I'm a failure. Look, no one is big enough to fight a bank alone. No one is. No one. I wouldn't do it, and I do this for a living. Okay, there's no greater joy in my life than beating up on one of the big banks. It's my favorite thing in the world to do, and I still wouldn't do it alone, because they have far more resources than you or I alone can marshal. You need help. You need support. And so you cannot be afraid to ask for help because you have some notion of what you think your responsibilities and expectations are. No, we're beyond that. This is beyond fear or shame or strength or weakness or pride or faith or any of that. This is about doing what we have to do as a community to keep together as a community. Okay? Talk to an attorney. Look, community legal services, maybe you like me over this talk, maybe you don't, whatever. Look, you get a half an hour of me for free, and I will go through all the paperwork you give me, and we will talk about it and what your options are and what might work for you and what might not. And I can get way more specific about all these issues. And, or not me. Look, there are other pro bono providers. There are private attorneys through the Prince George's County Bar Association, all sorts of people out there. Talk to us. We know the rules, we know the options, and we can talk about how those apply specifically to your situation. That's what we do. We identify risks, okay? We can explain the timing and how to use it to your advantage and everything else. That's what we're here for. Use us, please. Just as an aside, my general rule that I give all my clients, I call it my 3% rule. Whatever thing you're about to do, I don't care what it is. You ask yourself, what is 3% of the value of that thing? Can I talk to an attorney for that amount of money or less? And if you can, you probably should. Works for any transaction. You're going to buy a can of Coke for $1. 3% is 3 cents. Can you talk to an attorney for 3 cents? No. You can't hire anybody for 3. You can't even hire your grandchild for 3 cents, right? So you're probably safe buying a can of Coke on your own. You knew that, but it's good to see that the rule works, right? You're going to buy a car for $50,000. 3% of that is $1,500. You can get your contracts reviewed. You can get your car dealership looked at. All that stuff for under that $1,500 probably. And it's probably worth it. And when you're talking about a house worth $200,000, I don't think I've ever heard of an attorney charging $6,000 to help a prospective home buyer review their basic documentation for that amount of money. So yeah, you can get help for a lot less than that. And you really should. because I don't think any of us actually sat down and read through that big stack of papers that came at us at Mach 50 while this closing attorney said, here, sign here, now sign here, now sign here, now sign here. And I said, do you know what you signed? Ask yourself. But if you had an attorney, he or she would and could tell you whether or not you should and what to look out for and what they really mean. Talk to your loan servicer. A lot of times people are afraid to talk to their loan servicer because they feel like, am I going to say something wrong? Am I going to give something up? Am I going to look? You can talk to them. Just maintain really good notes. I'm going to tell you how to talk to them. It's actually a really good technique for it. Okay. Really good notes. No back of envelopes. No napkins. No chalkboards. No dry erase boards. No, none of that. Get a journal. Use 1 page per conversation at least. Use what's known as the mirror technique. Let me explain. You want to say to them something like, hi, I'm trying to find out the status of my loan. Could you update me on the status of my loan? And I don't know, Jeff or whoever the person is on the other side of the phone is going to say, well, let me look and see. I can see that your last payment was received on such and such date and you paid so much and blah, blah, whatever they say, right? Then you're going to say, okay, so I just heard you tell me that my last payment was received on such and such date in the amount of such and such. It was posted this way. It was recorded in accounts that way. And Jeff will say, yes, that's correct. Or Jeff will say, no, you made a mistake here. And you go back and forth until you both agree as to exactly what was said. And that's what goes in that journal. And after that's all done, whatever specific actions you were seeking, you say, all right, so Jeff, your bank is going to do the following things. And then I'm going to do the following things. And the deadlines are whatever they are. And you're going to mirror back and forth again until you and Jeff agree what those actions are. These records constitute records kept in the ordinary course of business, which means there is a basis to try to move for their admission, which means we have a way to use them. Because the number one problem I have with clients who want to argue about whether the bank told them something or didn't is they say, well, the bank told me this. Okay, when? Who? What's their extension? Do we have any evidence of that? Look, the banks record all of your conversations. And if I talk to Jeff, extension number at such and such time Eastern on this date, I can subpoena the bank for that taped conversation and we can hear Jeff say exactly what Jeff said. And then a case which didn't have any wings might. But this has to be your job. It can't be the attorney's job because we can't call every homeowner's bank every day, especially before there are clients. It starts with you, the homeowner, and this is a big area where you can take power. And I have had judges look at some of my clients' immaculate records versus whatever the heck the bank's attorney could whip out at the hearing and just say, I find the homeowner more credible. And my client wins. And it's just as simple as that sometimes under the right facts. But you have to create the environment for them. And that's what these steps that you can take are. You're creating the environment where, with appropriate help, you can have success. Okay? Again, use terms precisely when you talk to the bank. We review them. This talk is going to be recorded. You can go back and hear me explain the terms again. Use them precisely so you know exactly what you're asking and exactly what you're hearing. And be clear about what they're going to do, okay? And the deadlines and when they're going to happen. Here's an example, just so you can see, of the way I keep a log or encourage my clients to write the date, the time, the phone number you called, the company, bank, service, or whatever you called, the agent, hi, this is Jeff, agent ID, whether he has an ID number or an extension or an email, something that identifies Jeff, right? Because he's 456-290 or whatever the heck it is, depending on their phone systems. There's a way to find Jeff and call Jeff up. I guarantee it. Your notes and these actions, right? And again, I mean, they're condensed here. Make as much space as you need. I don't care. Take 5 pages for these conversations, but keep them and keep them organized. Gathering documents. This is the most document intensive area of the law. Your attorney, if you come to see an attorney, is going to need the most recent mortgage statement you've got. This thing has all sorts of information on it. It's a gold mine. Have an idea of what your current mortgage balance is. It's really important for evaluating options for you, okay? Loan documents, the big folder. We all got these super long legal size folders with all of our documents when we took these loans out. They love to put this on 8.5 by 14 paper. I don't know why, but they do. They love the long paper. Fine. Find those documents. Those are ridiculously important. They have everything we need. If the reason you ran into trouble was because you had temporary loss of employment and now you've gotten employment, letters for your new job offer, incredibly important. These are all things that are going to need to be provided to the bank to work things out. And probably the most important thing, where most of these cases get worked out, is the budget. Where does all the money go? And look, be honest. You know, my favorite thing are the clients who budget some amount for their entertainment. Because let's be real, we have to continue to want to stay here on spaceship Earth. That's maybe a rather indelicate way of putting it. But look, there's something we are here for. I hope we aren't all here living just to pay our bills. I mean, there's art, there's music, there's something that gives us life, and that needs resources. Maybe not a lot, but it needs resources. And so budget for it, and budget for it without shame. Okay, and we can talk about amounts of things, but it's got to be there because you're humans. You need to feel love, to feel life, and that's okay. And you don't need to feel guilty about it. Please don't feel guilty about it. And you certainly don't need to hide it from your attorney who's just trying to figure out how to help you out. Okay? Consider all your options. All right? The top one I have here is it best to keep your home? This can be a real tender one, particularly with elderly clients who have lived in their home for 47 years and their husband just passed and this is where they raised their babies and all that other stuff. Look, I get it, okay? But here is something very real that you need to understand. Cities and places near cities are places where people are constantly coming for work. The reality of that means that fuel and utilities and food and are constantly going to be pressuring your budget, which if you're an elderly person means you have recently probably transitioned to a fixed income. And I don't care how generous the tax incentives are from your local government, they can only do so much. The home exemptions only go so far because all these other things which they have no control over are going to put tremendous pressure on you. And the question is not if, but when is it going to destabilize you? Now, maybe you're well-resourced enough that when is someplace probably after you're dead. Great. But maybe not. So it's important to look at what is the interest of your longest financial stability. And please don't take this as I'm saying, get out. No, I don't want anyone to have to leave, but you have to look at it. It's really important. So is it best to keep your home? If it's not, what happens if you don't? What's your plan? How's that going to work? What's your transition plan? If you're older, you have doctors. How do you see doctors? How do you see your medical care? How do you sustain life? What do you want to do? And to all of this stuff, it seems to me the most important question is, what makes you happy? What do you like? If you like to fish, maybe there's someplace you can move where you can just fish all the time. That's less expensive and it makes sense. So figure out what it is that makes you happy and how it's going to make sense and how this can form a plan that's going to mean ultimately your success. Because sometimes success isn't keeping the home, as painful as that may be to hear. Okay? And here's another one. Are there other things that if you gave them up could make your current home work? I had a client that I had what I didn't think was going to be a painful conversation, because obviously my values are not the client's values, but it's the client's life. So, of course, whatever the client decided, they were right. But the client had 6 cars. Single person had 6 cars. And I said, your car insurance is $3,000 a quarter. And if you went down to 1 car, you're probably somewhere less than $600 a quarter, and then you're probably fine. And we ran the numbers, and sure enough, I was right. And if he further, because his cars were all actually collector cars and stuff, if he sold them and he bought, like a hybrid, like a Prius or something, so his fuel economy got better, boy, he was set. But this was what he really loved. His 6 cars. This was the reason he's breathing in and out here on Earth, right? So what seemed a fairly simple and obvious conversation to me was not at all. But I think you have to look at it, even if it's painful, because ultimately, if you can't keep the garage where you keep the 6 cars, what's going to happen to the cars you love anyway? And how are you going to make all of this work? So I think you really need to spend some time figuring out your plan. And that can make everything else kind of fall into place, because ultimately, even if you hire an attorney, our job is to help you reach your goals. But you have to define what those are. And that's what we can work on. Okay. You, of course, can apply for a modification. Here it is, modifications. Modifications can change the terms of your loan and make it possible for you to keep your loan. It's almost always going to cost you more money in the long run. Okay? You're extending your term, you're changing the payment schedule, whatever. It has to make more money for the bank to modify it than not to modify it. Otherwise, they're going to say no. Okay? So a modification is not desirable in terms of the total amount of money you're going to pay. It never is. The question is the modification going to make it possible for you to keep your home if that's the goal? And if so, you should consider it. Please understand the following things. You do not have a right to a modification. You signed a contract to pay money on a certain schedule under specific terms that you are now in breach of. You don't have a right to this. And the courts have ruled this way numerous times. Okay? You're asking for a modification. And it has to be in the lender's interest. Okay? And it's on you to demonstrate that it's feasible, which gets back to those earlier points of saving money, showing income, showing you can live in your means, showing them a plan that says, yes, this works. And here's the other thing you need to understand. Simply put, a bird in hand is worth 2 in the bush. I've had clients who have been offered modifications that actually increased their mortgage payment by $25, and they refused them, outraged. This modification is supposed to lower my payment. This one increased it $25, blah, blah, blah. And I had to say to them, okay, Why did you fall behind? Well, I fell behind because my kid got sick and I had medical bills. Okay, understandable. Can you afford this extra $25 a month? Well, yeah, I can afford it, but the principle is that no, look, they aren't required to offer you anything. And if you can afford this offer that they've given you, understand this ends the foreclosure here, now, today. And if you say no, then the bank is going to stand in court and say, we offered them a reasonable accommodation, Your Honor, and they refused us. And who looks like the bad actor? Because you don't have a right to it. You need to understand that when it comes to these things, if it is at all feasible, it's kind of like they really are negotiating almost with a gun to your head. And the question is, do you want them to pull the trigger? And you need to understand that when you go for these negotiations with the bank. Okay? Reverse mortgages. Severe caution on these, particularly for, elderly residents are the only ones that this is available to. Let me be clear. If you have a house worth $300,000 and you only owe $30,000 more on the mortgage, I know you've lived in this house 50 years, whatever, and you're tied to it. I know. But what the bank is actually proposing by a reverse mortgage is that they will give you up to 65% of the value in your home in a new loan. So roughly speaking, on $300,000, that works out to what? About $180,000 worth of loan, $190,000, something like that. Okay. That will pay off your original $30,000 balance. Then there's closing costs and fees, blah, blah, blah. Maybe you get $150,000 in cash. And that feels good, and I understand that. But understand that $195,000 is going to bear interest every month, which means the balance is increasing. That's why this isn't what we like to call a reverse mortgage. It is more properly called what its actual name is. It is an equity conversion mortgage, which means after about 5 years or so, there is no more equity in your house. You cannot sell it. You cannot leave it to your grandkids. You cannot do anything. And if you spend money to repair it, as the contract says you must, you are investing money in the bank's house. Not your house, the bank's house. Now, if your ultimate goal is, I want to stay in this house no matter what, I don't care, damn the consequences, we're staying, fine. But understand, you are giving up the wealth and equity of your house. When you do this, when you make this decision, you are giving it up. And so if you take this $150,000 you get and you use it to make improvements on the house, you have done nothing but make the bank even richer. And you have given it away. You need to talk to an attorney before you enter into these. Before you enter into these. I will give you an example. There was a house, husband and wife, who got a reverse mortgage. And the bank said to them, gee, we'll give you whatever the dollar value was. Let's say it's at $195,000 if you both are on the deed. But I'll tell you what, if we redeed the house so that only Frank is on the mortgage and you, Thelma, you aren't on the deed. Only Frank is on the deed. Frank's the only one who owns that. And you, Thelma, are not anymore. We'll give you $200,000. Good deal, right? And they did it. And what did that mean? The bank gave them more money because statistically speaking, Frank was going to die sooner. So when Frank died and Thelma thought she was safe in her house, Thelma was not safe in her house because Thelma doesn't own the house. And the reverse mortgagee, Frank, died. That house now belongs to the bank. But no one explained that to Thelma when they signed all these documents. She didn't know. They aren't there to help you. They are there to make money. And you need to understand what you're giving up. Now, if you have no children, you have no family you want to leave this house to, you don't care what happens when you leave Spaceship Earth, this may be a great option for you. May be appropriate. But you need to understand what the consequences are. Yes, this can save your house from a foreclosure. But where are you going to with it? Okay. Steps you can take to understand the process. You can watch this video as much as you want. You can also go to the Department of Labor Licensing and Regulation website, DLLR. There's a graphic for the process. There's an information sheet. There are links for consumer protection there and other things. You can also look online for the Maryland rules and the Maryland code. The easiest way is to look for either the Westlaw or Lexis links. Just search Maryland rules, Maryland code. You want to look at Maryland Rule 14 when it comes to foreclosures. And you want to look at Real Property Code Title 7. Now, the Maryland Code, for those of you who don't know, is actually organized by word descriptors. So there's agriculture, commercial law. Real property is the one you want to look for. So just it's alphabetical, go all the way to R. And you want Title 7, which has to do with mortgages and deeds of trust. Okay. And let's see, what else? So there we are. We're at the end. We made it, everybody. Hey! And not too bad. Hour and a half, hour and 45 minutes. I'm sorry, I talked too much. Ultimately, the only way to learn this stuff is by doing it. You cannot be afraid to try. You cannot be afraid to reach out. You cannot obsess about getting the best deal. There is no best deal. There is no one way to do these things. It's all about creating an environment to where your lender says yes to continuing a relationship with you. And just like any relationship between any people, no two marriages are the same. They just aren't. Don't wait too long before talking to an attorney. Remember, talking to a bankruptcy attorney doesn't mean you're going to file bankruptcy, but it does mean you're going to try and get an understanding of what that option looks like for you. And at this point, I will happily entertain any questions anybody has. Oh, we want last letters for the websites. 1 second. Let's see. Let's see here. Covered by photos. Okay, so the let's see if I can share the screen again. Okay, let's see. You can all actually swap your photos to the other side and just put them over the slide navigation, and then you should be able to see the things more appropriately. Can you see them all now? Does that work? Okay, but this will all be there as well. Okay. Okay. And hopefully these links will all work and transfer okay in the live version where people can look at them somehow. Are there any other questions? No, everybody's just very, oh, someone else. Okay. Oh, someone says, what do I recommend for someone with limited income? The first thing I would do is come and talk to us at CLS. Again, half an hour, I'm free. I'll look at all your stuff and we'll figure it out. It doesn't, I'm paid by grants by the state and other people that are there strictly to help you. So I will absolutely happily do it, and we'll go through everything you got. One thing I will say is this, a general thing about attorneys, okay? And I guess about me specifically, okay? Our job is to help you out. And to do that, we need very specific information. So we dig for it when we talk to you. And sometimes that can make you feel a little bit like I'm an inquisitor and you're being tortured and all that stuff. I know that. I know it can happen. I try not to, but I'm digging for specific stuff. And so when you talk to an attorney, to a certain extent, be prepared for that. Be prepared for them to push you a little bit on some of the facts, because ultimately that attorney wants to get to the truth of the matter so they can frame the best response for you. And I know it can feel a bit judgy. I know. But that's the business we're in, and we're doing it to help you out. Oh, Jordan, can you unmute Councilwoman Anderson-Walker? Jordan? Let's see if I can unmute you. Oh, I can unmute you. I can do it. Unmute? Unmute audio? Oh, yeah, I did. Okay. Yeah. Oh, I keep clicking it because it's slow. 1 second.
Fantastic.
Ah, gotcha.
John Gabel, you have been absolutely phenomenal. Very thorough. I think you did a phenomenal presentation, and I cannot wait to get this out to people. I think they'll learn so much. There are a lot of questions I had about reverse mortgages. You hear about it all the time. I'm glad you answered many of those. And I think you've given people guidance and resources, more importantly, so that they can, depending on what their issues are, can tailor how they're going to react based on their specific situation. But thank you again. And I'm just so grateful for Community Legal Services for providing this service to us. And we look forward to following up with you. I'm sure individuals will do so. I'm sure that you put your contact information in one of the slides. Yes?
Let's look. 1 second. And if not, we'll have it at the end of the presentation. So I'll share screen. Let's grab that, share. And let's go, whoops, I'll move everybody over there again. And let's go up to the top. Well, let's make it easy for everybody here. Oh, no, I'm sorry. That's my old one. We want clspgc.org. There we are.
Awesome.
Okay.
Well, thank you so much for your time. And I hope you all have a wonderful evening or remainder of the day, depending on when you're watching this. And thank you again, John. Really appreciate you.
My pleasure. And good luck, everybody out there. And again, please don't hesitate to give us a call at Community Legal Services. Whatever your legal needs are, honestly, we do just about everything that isn't criminal. Criminal, you have to go to the public defender. But other than that, we're happy to help you out. So please, no question too small. We're happy to do it.
Appreciate you. Thank you.
Take care, all.
Have a good one.
Stop recording.